Hello everyone, welcome to the Law 360GH and to our first lesson on Ghana legal system. Today, we are treating the topic Sources of Law in Ghana's Legal System. And to ensure that our viewers grasp the understanding of this topic, we intend to follow this outline. 1. We are going to attempt a definition for sources of law. 2. We are going to figure out the importance of sources of law in the legal system. 3. We are going to distinguish between the sources of law of a legal system and the sources of law of the Constitution. 4. We are going to provide the sources of law in Ghana's legal system. And 5. Any other relevant information. We therefore crave your indulgence to stay with us throughout this discussion. Kindly subscribe to this channel, put your notification bell on, like this video, and share to colleagues, friends, and family. We also encourage you all to write down your comments at the comment section in order to help us recognize how well we are providing you with your expectations. Thank you very much for your understanding. Let us now turn our attention to the lesson and pick our outline accordingly. As I noted above, the first thing we are going to look at is an attempted definition for sources of law. The expression sources of law has a wide variety of meanings. Writers refer to formal sources, material sources, evidentiary sources, and intangible sources. The differing use of language has, however, caused some confusion. The distinction between a formal source and a material source is often employed in constitutional law. According to Salmond, a formal source is that from which a rule of law derives its force or validity. The material sources, on the other hand, are those from which is derived the matter, not the validity of the law. The material sources therefore supplies the substance of the rule to which the formal source gives the force and nature of law. In respect of formal sources, it is said that a formal source is a procedure and method for creating binding legal rules. It has been said that a formal source represents the mechanism through which the law comes into being, while a material source indicates where the legal rules come from, that is, where the rules are located. One writer has argued that formal sources constitute what the law is, while material sources identify where the law may be found. The expression source of law may mean that which gives the law its formal validity, that is, formal source, for example, the Constitution. Secondly, it may also mean the direct means by which law is made or comes into existence, and this is referred to as the legal source of law. For example, legislation and judicial precedent. Thirdly, it may also mean the written materials from which we obtain knowledge of what the law is or was at any given time, and this is referred to as the literary source of law. For example, Sabbath Fanti customary laws and Waitrace Ashanti law and constitution. Fourthly, it may mean factors that have influenced the development of the law and from which the content of the law may be traced, and this is known as historical or material source of law. Consequently, sources may be said to be those agencies by which rules of conduct acquire the character of law by becoming objectively definite, uniform, and above all, compulsory. And you can see this in Ghana Legal System by E.K. Kwanzaa. Thus, from the above, the definition as to what is meant by source of law is unsettled, but we may conclude by saying Source of law gives the legal system and communicates to us the source of power, authorities, the rights, duties, limitations existing in the legal system, and where to derive these essentials. Now, the next task we have on our outline today is to figure out the importance of sources of law in the legal system. In this section of our discussion, we have decided to put this part down and let you have it as your take-home assignment, as a form of reflecting on what we learned today. However, make sure you provide authorities to support your identifiable points. Maybe you will need someone to examine your assignment on this after you are done solving them. The Law 360GH will be available to examine it for you. Just email it to us via thelaw360gh@.com. I repeat, thelaw360gh@.com. Let's now move on to the next step on our outline. Here, we are going to look at the difference between the sources of law of a legal system and the sources of law of constitution. Looking at this section, you need to recap on what we did earlier on in our previous video on the nature and scope of constitutional law to pick up the sources of constitutional law. After you've done so, then you compare and contrast them with the sources of law we will identify under Ghana's legal system to help you get the difference. However, by way of a brief, the history and past experiences of a state, the laws, constitutions of other states, especially democratic and constitutional regime states, judicial decisions, writings of highly qualified scholars, among others, are some of the examples of the sources of constitutional law we need to recall. Therefore, be guided by these examples to make your comparison after the discussion. The next task on our outline is to provide the sources of law in Ghana's legal system. And in order to give better flesh to this section, the sources of law in Ghana's legal system are placed into two categories. A, the primary sources of law, and B, the secondary sources of law. Before we take the two categories and examine them, we may have to consider what we mean by the above categories and why this form of categorization. Generally, primary sources of law are laws emanating from official bodies under the legal system. These bodies must be authorized to make the laws. Secondary sources of law, on the other hand, are background researches. They explain, interpret, and analyze the primary sources of laws. Secondary sources are good ways to start research and often have citations to primary sources. Concerning the question, why this categorization? From the meaning of primary sources and secondary sources given, I guess the reason has been partially satisfied. The remaining half will be satisfied after examining the sources of law in Ghana's legal system using the two categories. A. The primary sources of law in Ghana's legal system. Here, we will only identify the source, locate its authority, and then cite examples. The first primary source of law in Ghana's legal system is the Constitution 1992, that is the Fourth Republican Constitution of Ghana. This can be found under Article 11(1)(a), Article 1(2), and Article 36(2) of the Transitional Provisions of the 1992 Constitution. Article 11(1)(a), Article 1(2) of the 1992 Constitution, and Article 36(2) of the Transitional Provisions of the 1992 Constitution. That is to clear all doubts. In New Patriotic Party, versus Attorney General, 31st December case, Akins JSC said, "In my view, even though Parliament has the right to legislate, this right is not without limit, and the right to enact a law that 4th June and 31st December should be declared public holidays cannot be left to linger in the realm of public policy. Such legislation must be within the parameters of the power conferred on the legislature, and under Article 1(2) of the 1992 Constitution, any law found to be inconsistent with any provision of the Constitution, which is the supreme law, shall to the extent of such inconsistency be void." Unquote. In the same 31st December case, Emwasechi JSA, also in support of the majority decision, said, and I quote, Parliament has no uncontrolled right to pass laws on public holidays any more than it has to declare a one-party state or make a party leader president for life or crown him emperor. As the fundamental or basic law, the Constitution 1992 controls all legislation and determines their validity. It is for the courts, as guardians of legality, to ensure that all agencies of the state keep within their lawful bounds. Unquote. At this point, you are required to find other cases that spoke about Article 1(2) and Article Constitution of Ghana. The second primary source of law in Ghana's legal system is enactments made by Parliament, also called Acts of Parliament, and you can find this under Article 11(1)(b) of the 1992 Constitution, Article 93(2) of the same Constitution, and Article 2(1) and 2(2) of the 1992 Constitution. In the case of Mensima versus Attorney General, it was emphasized by the court that Article 1(2) of the 1992 Constitution is the bulwark which not only fortifies the supremacy of the Constitution, but also makes it impossible for any law or provision inconsistent with the Constitution to be given effect to. And once the Constitution does not contain a schedule of laws repealed by virtue of its provisions, whenever the constitutionality of any law vis-à-vis a provision of the Constitution is challenged, the duty of this court is to examine the relevant law and the Constitution as a whole to determine the authenticity of the challenge. And in this regard, the fact that the alleged law has not specifically been repealed is totally immaterial and affords no validity to that law. For Article 1(2) contains a built-in repealing mechanism which automatically comes into play whenever it is found that a law is inconsistent with the Constitution. It therefore follows that the submission based on the fact that Regulation 3(1) of LI 239 has not specifically been repealed and is therefore valid misconceives the effect and potency of Article 1(2) and thereby underrates the supremacy of the 1992 Constitution. Unquote. Akins JSC, in the 31st December case, which has already been mentioned, added to his dictum above, and I quote, Parliament's legislative power is further limited in other respects. Its powers do not extend to the making of a law to alter the decision or judgment of any court, nor make it create a law which operates retroactively. Parliament has no power to legislate for the creation of a one-party state, nor can it make laws relating to chieftaincy without having referred the draft to the National House of Chiefs for advice. Finally, Parliament cannot make laws relating to financial and budgetary matters unless the bill is introduced or the motion is introduced by or on behalf of the President, unquote. You are hereby directed to find other authorities that oppose the legislative power making of Parliament and their limitations. Some examples of Acts of Parliament are the Lands Act 2020, Act 1036, the Right to Information Act 2019, Act 989, the Companies Act 2019, Act 992, the Local Governance Act 2016, Act 936, Banks and Special Deposit-Taking Institutions Act 2016, Act 930, and Income of Tax Act 2015, Act 896. Please do well to find other Acts of Parliament. Moving forward, the third primary source of law in Ghana's legal system is subsidiary legislations or subordinate legislations. This can be found under Article 11(1)(c) and Article 11(7) of the 1992 Constitution, the Statutory Instruments Amendment Act 1997, Act 539, and was also emphasized in the case of Osei Akoto versus Attorney General, suit number J1/16/2012. There are three types of statutory instruments, and they are legislative instruments, executive instruments, and constitutional instruments. Some examples of legislative instruments, or LIs, are the Civil Proceedings, Fees and Allowances Amendment Instrument 1992 and the Legal Profession, Professional Conduct and Etiquette Rules 1969 and the Environmental Impact Assessment Rules 1999 LI 1652. For some examples on executive instruments, kindly check all the executive instruments issued under the Imposition of Restrictions Act of Ghana 2020, of which they are famously called presidential declarations. However, some examples of constitutional instruments are the High Court Civil Procedure Rules, CI 47, Supreme Court Civil Procedure Rules, CI 21, and that of the Court of Appeal, which is CI 16. And finally, 2020 Constitutional Instruments, which was used to govern the elections, CI 127. In light of the above, please do well to identify the differences between the three types of statutory instruments and find more examples. Another primary source of law in Ghana's legal system is existing law. This can be found under Article 11(1)(d), Article 11(4), 5, and 6 of the 1992 Constitution. Please do well to find cases which talk about the existing law. Some examples of the existing laws are the Contract Act of 1960, Act 25, the Legal Professions Act 1960, Act 30, and the Sale of Goods Act 1962, Act 137. Fast forward, another primary source of law is the common law. And this is stipulated under Article 11(1)(e), Article 11(2) of the 1992 Constitution, the Interpretation Act of 1960 and 2009, and the Judicature Act of 1874. Please find examples of common law rules that exist in Ghana through the cases, and also look for the maxims of equity. The last primary source of law we are going to talk about is the customary law. And this is stated under Article 11(1)(e), and Article 11.3 of the 1992 Constitution of Ghana. However, by way of exception, cases and international conventions are considered as primary sources. Thus, all judicial decisions of Ghanaian courts, especially the superior courts, which are known as the courts of record, are to be included to the above primary sources of law established in Ghana. Also, international conventions or treaties that Ghana is a party are primary sources of law in Ghana. See Articles 40, 73 and 75 of the 1992 Constitution. Also see the 31st December case, the case of NPP versus Attorney General, that is the SIBA case, and the Libertad case. Now we are going to take a look at the secondary sources of law in Ghana's legal system. Here, we are referring to textbooks written by law lecturers and legal practitioners and judges on the various aspects of laws in Ghana. We are also talking about other highly recognized books and articles written by high Ghanaian scholars. Another example of secondary sources are the directives made by the Bank of Ghana, the Auditor General, the Registrar General, the Commissioner General of GRA, among others. Let us now turn our attention to the final part of our discussion for today. In drawing the curtains down on our topic, Sources of Law in Ghana's Legal System, we believe that you have come to identify, understand, and appreciate the following. 1. What is meant by source of law of legal system and source of law of constitution? 2. The relevance of having sources of law in our legal system. 3. The categories of sources of law in Ghana. From our discussions above, you will realize that the examples given under the enactment of Parliament did not make mention of enactments made before 7 January 1993. It is recommended that all enactments made before 7 January 1993 should be grouped under existing laws, that is, under Article 11(1)(d) of the 1992 Constitution of Ghana. We also hope you find time to try your hands on the following questions. Thank you for spending your precious time with the Law 360GH to undertake our tutorial session today. We humbly invite you to subscribe to this channel, like this video, put your notification bell on, and share the link to all places so they join you benefit here. You can reach us via email on thelaw360gh@gmail.com. I repeat, thelaw360gh@gmail.com. Best wishes, goodbye, and catch you later.